Hello friends, hi, hope you all are doing good. In this particular module, what we are going to discuss is a particular case law of the Mumbai Tribunal which is held in the case of Linklaters. It pertains to India-UK DTAA. More specifically, it relates to a issue of service PE, as in when the employees of the foreign company or any other person of such company is deputed in India for an assignment in India for more than 90 days, then what do we need to consider for the purpose of determining permanent establishment? Do we need to consider manpower, man days, or do we need to consider solar days? So as it was held in this case, and as it is a view which is taken in general, which is supported by various case laws of the various tribunals, the view in general is that we need to consider the solar days and not the man days while determining the period of stay, that is the number of days by which the service is provided. Let's say there are 10 employees who are providing services for 80 days. So in total it will become 800 days, right? If we consider man days. But is it possible in a particular financial year or in any 12 months period to have 800 days? So no. So these are some of the arguments which is laid down in various case laws to support that we need to consider solar days and not man days. In this particular judgment, which was represented, this particular case was represented by J.D. Mistry, and the Mumbai Tribunal has held in favor, which says that we need to consider solar days and not man days for determining the period of stay in India for computing or for determining permanent establishment. Besides, a question may arise that a person is deputed in India for, let's say, 80 days and he wants to stay in India for 30 days or more additional days for some vacation, for doing some additional studies, or for any other personal reasons, and which is not related or which is not connected to the service which he is ought to perform in India. So the question arises, do we need to consider this vacation period in determining this 90 days mandate? So again, it was held that we need not consider this vacation period as it is not related to the service being provided. So it specifically relates to Article 52K of India-UK DTAA, which defines the term permanent establishment. The assessing officer has held that SSE had a permanent as a permanent establishment during the assessment year 2002-3 in terms of Article 52K1. Therefore, the only issue which was required to examine is whether the employee or the other personnel of the company have stayed or rendered services in India during the financial year 2001-2, exceeding the period of 90 days in order to constitute a permanent establishment. In this contention, the assessee has laid down or placed reliance on the several judgments, which also includes the judgments of Mumbai Tribunal in past, and this case has ultimately been in favor of assessee. So this was not anything which is out of the way judgment or anything. I just wanted to lay down or emphasize that there is one more recent judgment which has come to support a view that we need to consider solar days and not man days, as well as if there is any period, let's say vacation is taken by an employee, that particular period is not to be calculated in the period of stay in India for the purpose of determining permanent establishment, as it is not related to the service being provided.